For those of you that don't know, I'm Natalie Kearney. I'm a member of the Business and Property Juniors Group within St Philip's Chambers. I've been a member of Chambers since October 2018, or at least a pupil 2018, and a full member from October 2019. The topic we're talking about today is summary judgment applications for specified sums. In terms of any questions you might have during the seminar, just beneath you, or beneath my face, you'll have a Q&A button. If you want to click on that during the webinar, type in your question. You can mark it as anonymous if you don't want to put your name to it. If you do put your name to it, that's fine. At the end of the seminar, I will go through those, collate them into a document, and we'll put out the most common questions with some answers to those after the webinar, so that if there's a common topic that's being raised, a common issue that's being raised, you can have some answers to that as well after the webinar. I will try and keep an eye on it as we go along as well, just in case I can answer it as we speak, but if not, be reassured I will see it and I will answer that as I can. Okay, I think we'll kick off. People may be joining us as we carry on. If you join and I'm still talking, then this will be recorded anyway. So the recording of this will be uploaded onto LinkedIn and the Chambers website in due course, hopefully before the end of this week. And as I said, the newsletter with any questions and answers to those questions will hopefully be out at the latest next Monday. So I'm going to now share the PowerPoint that I'll be talking through. So my face will vanish into a small corner in the top right. Feel free not to look at me, but to look at the slides instead. So hopefully, let's just make sure that the screen is about to share. Here we go. So there I am in the small top right corner, but we have here the slides that I'll be talking through. So today we're talking about summary judgment applications for a specified sum. And the reason for that is we now have the County Court priorities list that's been published, the most recent one. And this sets out in priority 2 the work that could be done. So we have priority 1 list, work that must be done, priority 2, work that could be done by the county courts. Just to be clear, this only relates to county courts and priorities, not the business and property courts, not the high courts. But you'll see there in bold, applications for summary judgment for a specified sum are work that could be done by the county courts in this current time. So what we're going to be looking at is, when is it appropriate to make these applications? What's the court going to look at when they do it? What happens if your application is successful? What are the cost implications for the client? Because we all know that's the most important question you get asked. And then tactics. So should you be pairing the application with strikeout application? When should you be making the application? So a quick reminder, I'm sure all of you are familiar with CPR 24, but in case the caffeine hasn't clicked in just yet, you can get summary judgment on the whole or part of a claim. The question really is 2 parts. So firstly, you're applying to say there's no real prospect of the respondent either successfully bringing their claim or defending the claim. That it's false, fanciful, or imaginary, it's not better than merely arguable. Improbability is not enough, and we'll circle back to that when we look at the outcomes that can happen on your application if a judge isn't persuaded that the case is false or fanciful, but does think perhaps it's highly improbable. But the second element, and this is often overlooked, at least in the application notice, is that there's no other compelling reason for the matter to proceed to trial. And we'll look at exactly what that means as we go through. But do make sure it's mentioned in your application notices. There have been judges known to force advocates to make applications to amend the application notice where that's not mentioned, even though in the witness statement it is in fact addressed. So what do we mean by a specified sum? Well, exactly what you think we mean. You know exactly the amount that you're claiming. So let's say it's a debt claim on an unpaid invoice. You're claiming for a specified sum. What about damages? Because often breach of contract, you seek damages, consequential losses, that kind of thing. Well, damages generally fall to be assessed by the court. And so damages aren't a specified sum and are unlikely to be within the court priorities list, priority 2, for the county courts at present. But there are circumstances where damages can be treated by the court as a specified sum. For example, let's say we have a claim for a damaged item. The claim, in fact, is for the cost of replacing that item. If the cost of replacement is in fact known between the parties, that is definitely the cost of replacement, the court may in fact treat that claim, although it's for damages, as a claim for a specified sum. It will depend on the facts of the case. It will depend on the judge you get on the day. In terms of listing priorities, it's highly unlikely you're going to get a listing officer looking at your claim for damages and saying, well, really it's a specified sum, it probably is court priority 2 work. But it may be relevant in relation to costs further down the line. It's just something to be aware of. The court may decide that a claim for damages is a specified sum. So when is your application going to be appropriate? I've done a little table here. So it's probably appropriate if you've got a claim where the defendant's disputing facts that are raised in the claim, but in fact they don't really alter what the claim is for. The case often looked at in relation to this is a case in relation to a loan agreement. It's a case of Sagacor Bank Jamaica Limited and Taylor Wright from 2018. It's a Privy Council case. In essence, there was a dispute over the date of a promissory note. There wasn't a dispute as to the content of the promissory note, so the claim ultimately would have succeeded even if the facts the defendant was disputing had been decided in her favour. So summary judgment on a case like that, where the defendant's saying, well, this isn't what happened, doesn't ultimately change the contract they've signed, for example, the application of summary judgment is most likely appropriate. It's also probably appropriate where you've got a case that's very simple, straightforward facts, straightforward law. If we take the example of a hire car, let's say you've got a claim for payments that haven't been made in relation to a hire purchase agreement. The defendant's saying, well, I've sold the car, so why should I keep making payments? I'm keeping the profit I made from selling the car, but you should go after the new owner for the payments. As we all know, that's actually quite a straightforward case in law, and is probably appropriate for a summary judgment application. It's probably not appropriate, as you'd expect, where we're looking at complex facts or complex law that effectively are asking the court then on your summary judgment application to conduct a mini trial. And it's also probably not appropriate where we have insufficient evidence at the application stage for the court to make a decision, because they may want to go through disclosure first. We'll come back to this on timing. Or on that third point there, the evidence that we're asking the court to examine actually needs to be examined at trial. Because as you're all aware, a summary judgment application is based on witness statements. If what we're disputing is an oral agreement, for example, or dishonesty, forgery, fraud, those are topics that are perhaps best explored in cross-examination at the subsequent trial. And so a summary judgment application is probably not appropriate. The last box there, where similar issues remain to be decided at trial between the defendant and other parties. This is the reluctance of the court generally to get involved in circumstances where we have a claim against the defendant, but getting summary judgment on our claim may impact on the claims by the other parties and to some detriment prevent the court then deciding matters in the other proceedings. In the very bottom there, you'll see public interest is a little bit unclear. That the case that is in the white book and is the sort of leading case on whether public interest should be a matter that prevents you from getting summary judgment is the case of Burnson and Tate, 2015. It's a Court of Appeal case in which the judge said, well, there's no real prospect of success. I can't see the compelling reason for trial, and dismissed it. And there was an appeal to the Court of Appeal saying, well, effectively, the question here is the lending practices of banks, and the court should examine the lending practices of banks because it's concerning. The Court of Appeal accepted perhaps there were concerns about the lending practices of banks, but that didn't mean in and of itself a claim with no real prospect of success should still proceed and cause the parties to incur costs. So in that case, summary judgment was appropriate. So that brings us on to what the court's going to be looking at on your application. So the burden of proof. The applicant has to demonstrate that the other side has no real prospect of success. As we discussed, that means it's not false, fanciful, or imaginary. The applicant also has to say that they don't know of any other compelling reason for the matter to proceed to trial. It's then for the respondent to prove that there is another compelling reason for trial, and whether that relates to a public interest, with the caveat previously mentioned, or whether it relates to set-offs or counterclaims. So, as you'll see there on the second bullet point, if the defendant can show they intend to raise a set-off or counterclaim and the court satisfies it's a triable issue, and by that we mean it's not false, fanciful, or imaginary, then the claimant might not be entitled to summary judgment on their application. That comes with its own caveats. So summary judgment may be awarded in part. Let's say your claim is for 20,000 and the set-off claim is for 3,000. Theoretically, even if that set-off succeeds, you would be entitled to 17,000. So you may be able to get summary judgment for the part that doesn't overlap. There's also the question of no set-off clauses. So if you have a no set-off clause and you're pursuing a claim under that arrangement, that contract, the court generally will enforce the no set-off clause, but it does retain ultimate discretion not to in exceptional circumstances. So something to be aware of, that if you have a clause, you can ask the court to give you summary judgment on the whole and treat set-off as entirely separate. But the court does retain discretion in those circumstances. So what happens then to the application? So your outcomes are that you get judgment on the claim that you're seeking, the striking out or dismissal of the claim if in fact you're seeking summary judgment as the defendant, dismissal of your application for summary judgment, or a conditional order. And it's conditional orders that I'm going to look at next, because as I mentioned, improbability won't get you home on a summary judgment application, but it might get you a conditional order. So the court's heard your arguments, thinks, well, I don't think it's so terrible a case that it's false, fanciful, or imaginary, but it's highly improbable that what the defendant is saying is true, or is the case, or is likely to succeed at trial. The court may therefore give a conditional order. So they may order that the respondent makes payment into court, so security for costs effectively, or it may require them to take a specified step to avoid their claim or the defence being dismissed or struck out, perhaps requiring them to pay orders that have not previously been paid, perhaps reword or replead their defence or particulars of claim. And the impact of that costs, usually, let's say your summary judgment application theoretically has failed, but you've got a conditional order. So you may be able to persuade the judge that you should get your cost of bringing the application, because ultimately it was found that the respondent in some way has failed. But it will ultimately be a question of the court's discretion on costs. So what do we mean with costs for these claims? So are we subject to fixed costs? Because we're looking specifically at claims for a specified sum, you are in the fixed cost regime under Part 45.1, subsection 2. If your claim's over £25, it's within the regime. That means you've got commencement costs set out in Table 1, you've got costs on the entry of judgment in Table 2, and then miscellaneous costs in Table 4. Miscellaneous costs typically means if you've had to serve a party other than the parties to the claim, or for example, you're serving out of the jurisdiction. Just so you have some idea of what those figures would be. Let's say you've got a claim for £2,000, you've succeeded in your summary judgment application, so you've got a judgment for £2,000. What happens with costs? So your fixed commencement costs under Table 1 are going to be £80. Your cost and entry of judgment, so you've got your summary judgment, are £175. So that gives you £255 in fixed costs plus your court fees. So not a significant amount of cost recovery there, and something your client will need to be aware of when considering whether it's proportionate to make the application. Now, can you ask the court to depart from fixed costs? You can always ask. They retain the discretion on costs under 44.2 of the CPR. As any of you that are familiar with asking for unreasonable conduct costs in a small claim will know, the courts generally are quite reluctant to depart from fixed cost rules. The case in which this was considered is a Court of Appeal case, Aviva Insurance and Khan. In that case, the court considered perhaps it could depart from fixed costs where the conduct of the parties justified it. So if you do have some arguments, very much again with small claims where you have unreasonable conduct costs, you may be able to persuade a judge to depart from fixed costs. It will depend on your judge, the facts of the case, but ultimately do be aware that your client may only be able to recover fixed costs. Conversely, you may also find yourself facing an argument that if the value of your claim is below the small claims track limit and you haven't yet been allocated, there is a danger the other side will argue, well, if the matter had been allocated and you proceeded to trial, it would have been a small claim and you would have got no costs. So there is the argument there that the fixed cost shouldn't apply, it should be no cost because your matter is a small claim value. The combat argument to that would be to say, well, the table clearly provides for sums in claims under the £10,000 small claims track limit. But again, it's going to depend on your judge and their view of the conduct of the parties to that date. But I'd be fairly confident that you should have a good argument that fixed costs should apply in those circumstances. So what about tactics? So how about pairing your application with a strikeout application? So they're often brought at the same time. You'll have a strikeout or an alternative summary judgment application because your client wants this over quickly. They don't want to have to pay the cost of going through disclosure, preparing witness statements, going to trial. They think the other side's case is absolutely terrible. So just by way of comparison, the tests are different, as you're all aware. Summary judgment, as we've said, no real prospect of success and no other compelling reason for trial. A strikeout says there's no reasonable grounds for bringing that claim in the first place or no reasonable grounds for defending it. It's an abusive process to allow it to continue, or the respondents failed in some way to comply with either a rule, a practice direction, or a court order. So there are different grounds for those applications. And so you shouldn't necessarily default to seeking both, because you risk weakening your summary judgment application with weak strikeout arguments and vice versa. So if what you're seeking in reality is summary judgment, seek summary judgment. Don't weaken that application with strikeout. Also, in terms of our topic today, strikeout isn't in the court priorities list. Summary judgment is. So if you're interested in getting listed sooner and it's a specified sum claim, then perhaps it's best in those circumstances to simply seek the summary judgment application. But again, it will depend very much on the facts of the case. By way of an example, let's say you've got a breach of a loan agreement, you're for the claimant's got a signed written loan agreement because your client is great, and the defendant is saying, well, your client told me I didn't have to keep paying. But you've got written evidence from your client where they've emailed them saying, come on, pay. After the date, the defendant is saying they've been told they don't have to pay anymore. Well, there's not no reasonable grounds, because let's say the defendant is saying that it was an oral conversation. And it's theoretically something perhaps that could have been said. Let's say the defendant is saying, well, we're friends as well. This is a written agreement, but we're also friends. So it's not no reasonable grounds, and therefore strikeout perhaps isn't the best approach. But summary judgment probably is, because you have a written agreement and you have emails documenting that there have been efforts to chase a debt after that date. So next question on tactics is, when do we make the application? So again, with a caveat that each case will depend on its own facts. If the pleadings themselves disclose no real prospect of success, and it's unlikely there's going to be any key evidence that comes out of the woodwork at a later date, then after the pleadings have been filed and served, that is the stage at which you want to be making the application to prevent any further costs for your client. But you do be aware that the court will consider, as we've said, what evidence would be available if the matter proceeded to trial. So if the key dispute is whether an email was sent or not and it wasn't annexed to the pleadings, it may not be appropriate after pleadings are closed to seek summary judgment. But again, if you make the application, you would hope then behind the witness statement in response to that application, that key email would appear. But whether that would be the most proportionate way of getting that email and dealing with that matter is a different question. So when considering when to make your application, you want to be bearing in mind what your ultimate goal is, or what your client's ultimate goal is. Are they trying to prevent incurring further costs? Are they trying to force settlement with the application? So that brings me to my final slide here. What do you want to consider before we make the application? So what is going to be the impact on the costs for your client? So are the costs of seeking the application going to exceed the cost they're going to get under the fixed cost regime? Have you got a trial date already set? So this is going to delay matters. So is your client more interested in just getting it over and done with than they are in having the application dealt with, having a conditional order, for example, off the end of it, and then having to come back again with further directions, simply prolonging matters? Or are they more interested in seeing if they can get it kicked out early? Does it involve complicated facts and law, as we discussed? If it's complicated, you're probably not going to get home on a summary judgment application. You want to look at tactical impact. So if you're unsuccessful in your application for summary judgment, is that going to give the other side a boost? Are they going to say, well, fine, I'm not going to engage in settlement, I'm going to push all the way to trial, I'm going to have my day in court? Because as we all know, sometimes these sorts of procedural successes, if we can put it that way, can encourage the other side. Even if, let's say, the judge has said to you, well, it's not false, fanciful, or imaginary, I think it's improbable. But they don't give you a conditional order, they just give this stern warning. The other side may only hear what they want to hear. Well, your application failed and therefore I have a case and I'm going to have my day in court. So that may be a negative impact then for how you proceed. Also, is it likely to discourage your client? So is your client going to find that they've failed on the application? They're going to think, well, actually, maybe my case isn't as strong as I thought it was, so I'm going to settle this for less than I think it's worth. We know what the test is, false, fanciful, or imaginary. It's a high hurdle. But is your client going to be disheartened by that? And is it going to have an impact then on the ADR that would follow? So do consider the alternative options available. So as we mentioned, strikeout, in terms of priority listing, it's not in priority 2, but it may be the better option if what you're actually saying is there's no reasonable grounds for bringing that claim. And the court can treat a strikeout application as a summary judgment application under 3.1 anyway. Or is actually your client going to be better advantaged by seeking security for costs instead? If that's something that's potentially an option for you, as I've mentioned, my colleague Raghav Trivedi last week did the webinar on the topic of applications for security for costs, and that video is available on the Chamber's website, as I understand it, and also on LinkedIn. And I'm happy, if you want to contact me after this for me to send you the link, by all means do. And that's where we are on my presentation for you. As I've mentioned, if you have any questions, there is a Q&A button underneath my face again now. You can type in your questions to that. At the end of this, I'll collate those questions together and happily answer those. I can come back to you individually if you'd like, or I could, what I will be doing is collating the most popular questions asked into a document and sending that out as a newsletter. And then next week, my colleague Kirsty White, who some of you may know, we'll be doing a webinar like this on the question of witness statements. So you'll all be familiar with the fact that the rules have changed about statements of truth, for example, and talking about how your witness statement has been prepared and put together using your client's own words. And as I've mentioned, summary judgment applications require witness statements, not oral evidence. So I should hope that would then assist with any summary judgment applications you may be contemplating. So that concludes my talk this morning. I hope it's been helpful. You've enjoyed your coffee, had a nice breakfast, sat in your pajamas. If I can help anyone after this, do contact me. My email address is nkearney, which is KEARNEY, at st-philips.com. Or if you email my clerks from the website, they'll be able to put you in touch with me.